Magandang araw. I'm Angela Ocol from the Strategic Partnership and Advocacy Division of the Securities and Exchange Commission. Welcome po ulit sa latest webinar of the SEC Communication Advocacy and Network or the SEC CAN initiative. Under the leadership of Chairperson Francis Lim and Commissioners J.V. Paul D. Francisco, Carlo S. Bello, McGill Brian T. Fernandez, and Rogelio V. Quevedo. And of course, in partnership with our stakeholders from the public and private sectors under the SEC Campaign Network. Welcome to the second part of our webinar on Crypto Asset Service Providers, or CASPs. Just last week, we had the first installment of this series where we delved into the consumer side of crypto. During the first part of this series, our resource speakers defined what crypto is, how it can be used as an investment, and what red flags to look out for when it comes to crypto scams. Ngayon naman po, we will still look into the particulars of the two issuances of the Commission in relation to crypto asset service providers, mainly SEC Memorandum Circular Number 4 Series of 2025, or the SEC CASP rules, and SEC Memorandum Circular Number 5 Series of 2025 or the SEC CASP guidelines. Kasama pa rin natin sa webinar na to ang ating resource speakers mula sa PhilFintech Innovation Office and the Enforcement and Investor Protection Department. As with the previous webinar, they are here to help us understand more deeply these two memorandum circulars, specifically with regard to the rules that crypto asset service providers must comply with. Kaya kung gusto ninyong mas maging maalam pa tungkol sa mga regulasyong ito, we encourage you to stay with us until the end of this webinar. And at this point, allow me to reintroduce our panelists. From the PhilFintech Innovation Office, we first have Assistant Director Paulo Ong, Attorney Justine Gaverza, and Attorney Irish Dahua. And of course, from the EIPD Cyber and Forensics Division, we have Assistant Director Patrick Duane V. Patricio. And before we officially begin, babatiin lang po muna natin ang ating virtual audience via Facebook Live. Magandang hapon po sa inyong lahat. I-comment nyo na rin po kung saang lugar kayo nanonood ng webinar natin ngayon. Huwag nyo rin kalimutan i-share ang ating webinar sa inyong mga kamag-anak at kaibigan para mas mapalawak pa natin ang maaaring maabot ng webinar na to. Magandang pagkakataon din ito para mas matuto tayong lahat. Now, without further ado, let us have a walkthrough of the key provisions of the SEC CASP rules and guidelines through this video. Manood po tayo.
Good day, everyone. I am Attorney Justine Gaverza of the Securities and Exchange Commission, PhilFintech Innovation Office. Today, we will be looking at the rules that govern how we regulate crypto assets in the Philippines. On May 30, the SEC issued Memorandum Circular Numbers 4 and 5, Series of 2025. The first covers the SEC rules on crypto asset service providers, or CASP rules, while the second provides for the SEC guidelines on the operations of crypto asset service providers, or CASP guidelines. These memorandum circulars cover the registration and licensing of CASPs, the offering of crypto assets and crypto asset securities, and the marketing of crypto assets and crypto asset services, among others. Both had become effective last July 5, 2025. Now, you may be wondering why the SEC is regulating crypto assets and whether it even has the authority to do so. To answer that, we have to look at two laws: Republic Act No. 8799, otherwise known as the Securities Regulation Code, or SRC, and Republic Act No. 11765, also known as the Financial Products and Services Consumer Protection Act, or the FCPA. Under Section 37 of the SRC, the SEC is mandated to encourage competitiveness in the market by promulgating rules for the registration and licensing of innovative and other trading markets or exchanges, including the issuance and trading of innovative securities and technology-based ventures. Meanwhile, the FCPA provides that the SEC has the power to formulate rules and standards for the purpose of applying its provisions to specific financial products or services within the Philippine jurisdiction, guided by internationally accepted standards and practices. With the continued growth and development of new crypto asset markets, products, services, and business models, the SEC saw it fit to establish an affirmative legal framework that is in line with international standards to provide protection against consumer harms and systemic risks, and to afford consumers the choice of engaging in crypto asset activity with licensed and authorized intermediaries. Thus, the SEC primarily used the SRC and FCPA as basis for the drafting and creation of the CASP rules and guidelines. Before we delve deeper into the rules, let's first define what a crypto asset is. You may have heard of various terms floating around, such as cryptocurrency, virtual currency, digital assets, virtual assets, and other similar terms. The term crypto assets was specifically chosen for the CASP rules and guidelines because there has been a growing trend globally by regulators in the use of the word crypto assets as compared to other terminologies. Under the CASP rules, a crypto asset is defined as a cryptographically secured digital representation of value or of a right that relies on a cryptographically secured distributed ledger or a similar technology to validate and secure transactions that can be transferred, stored, or traded electronically. For the purposes of the CASP rules, crypto assets are classified as financial products, specifically investments defined under Section 3C of the FCPA in relation to the scope of the SEC's supervision. The CASP rules also make mention of crypto asset securities. Note that this is different from crypto assets. Under the CASP rules, crypto asset securities are defined as a cryptographically secured digital representation of value or of a right that is being offered as securities, as defined under the SRC and other relevant laws and regulation. They rely on a cryptographically secured distributed ledger or a similar technology to validate and secure transactions that can be transferred, stored, or traded electronically. This includes, but is not limited to, the digital representation of securities. The main difference between a crypto asset and a crypto asset security for the purposes of the CASP rules and guidelines is that crypto assets are classified as a financial product, specifically an investment under the FCPA. As such, they are regulated under the FCPA. Meanwhile, crypto asset securities are treated as securities as defined under the SRC, being offered in the form of crypto assets. Thus, they are covered by the provisions of the SRC and rules and regulations issued by the Commission in relation to securities. I would like to highlight that what the CASP rules and guidelines primarily regulate are not the crypto assets and crypto asset securities themselves, but rather those who are offering the assets and crypto asset services to the public, specifically the crypto asset service providers. The CASP rules define a crypto asset service provider, or CASP, as an entity that, as a business, offers or engages in the provision of one or more crypto asset services, including by making available a digital platform that provide these services. Crypto asset services are further defined as any or more of the following services and activities in relation to any crypto asset. This includes offering crypto assets to the public, operating a crypto asset trading venue, crypto asset intermediation activities, or other services related to crypto assets that may be determined by the Commission. Now that we know the important terms for our discussion, let's move on to the salient portions of the CASP rules and guidelines. Let's start with the registration process for a CASP under the CASP guidelines. A CASP must first secure a CASP license with the SEC before it commences operations in the Philippines. Any entity that wishes to register as a CASP must meet the following minimum requirements under Section 2 of the CASP guidelines. First, the applicant must be a corporation registered with the SEC. Second, the operation of a CASP must be included in the primary purpose of the corporation, as indicated in its articles of incorporation. Next, the corporation must have a minimum paid-up capital of at least 100 million pesos in cash or property, excluding crypto assets. Fourth, the applicant must have a physical office located in the Philippines, which must be appropriately staffed or manned during regular business hours. And lastly, the applicant shall submit CASP Form 1 together with the certified documents as listed under Section 2.3.1 to 2.3.15 of the CASP guidelines to the PhilFintech Innovation Office at fintech@sec.gov.ph. CASP Form 1 can be downloaded in either Microsoft Word or PDF format on the SEC website. Only after securing a CASP license can an entity legally conduct a public offering of crypto assets in the Philippines. Now let's move on to the public offering of crypto assets. Section 5 of the CASP rules provides that crypto assets shall not be sold, offered for sale, or distributed in the Philippines without complying with the provisions of the CASP rules and guidelines. To conduct a public offering of crypto assets in the Philippines, a CASP must file a disclosure document with the Commission and publish the same disclosure document on the platform's website, social media account, and other means of communication not less than 30 days before any marketing activities related to the offering or the actual offering, whichever comes first. The contents and specific disclosures required in the disclosure document can be found under Section 5 of the CASP rules. A disclosure document applies only to crypto assets. The requirements are different for the public offering of crypto asset securities. The CASP rules provide that crypto asset securities shall not be sold or offered for sale or distribution within the Philippines without a registration statement duly filed with and approved by the Commission, as provided by the SRC and other issuances by the SEC. Prior to such sale, information on the crypto assets in such form and with such substance as the Commission may prescribe shall be made available to each prospective purchaser. Remember, as opposed to crypto assets, which are classified as a form of financial product, crypto asset securities are classified as securities, as defined under the SRC. As such, the public offering of crypto asset securities requires a registration statement duly filed with and approved by the Commission in line with the provisions of the SRC. Initial coin offerings, or ICOs, are also covered by the CASP rules. ICOs refer to any activity or event and any subsequent activities or events in which a person or entity offers participants a unique digital coin or token in the form of a crypto asset in exchange for consideration for the purpose of fundraising. The tokens are issued and distributed on a blockchain or cryptographically secured ledger. ICOs are covered under Section 6 of the CASP rules if the facts and circumstances, as well as the economic realities surrounding the offering, can be characterized as sales of securities as defined by the SRC, SEC issuances, and other relevant laws. In relation to the public offering of crypto assets covered under Section 5 of the CASP rules, a CASP must also comply with the requirements under Section 4 of the CASP guidelines for the admission to trading of crypto assets. They are that a CASP shall ensure that all available information from reputable or credible sources pertaining to the products being traded in the system is provided to the investors, and that the CASPs must maintain and implement clear and objective listing and delisting standards regarding crypto assets and must apply those standards when considering the admission to trading, suspension, or delisting of crypto assets. We would like to emphasize these three important points in relation to the admission to trading of crypto assets. First, the SEC shall have the power to order the removal or suspension of a crypto asset in a CASP in the interest of investor protection. Second, crypto asset services may not involve crypto assets having features that are prohibited as prescribed by the Commission, including, but not limited to, those related to gambling activities and obfuscation of identity and/or transactions. Lastly, unless allowed by the Commission, CASPs should not conduct any offering, trading, or dealing of derivatives involving crypto assets, as well as offering trading on leverage. In addition to the registration requirement for the public offering of crypto assets and crypto asset securities, the SEC also regulates the conduct of marketing activities of such products. Marketing under the CASP rules is defined as the act of communicating, offering, promoting, advertising, or delivering crypto assets or crypto asset services. Section 7.1 of the rules provide that no person or entity shall engage in the marketing or inducement to purchase crypto assets or crypto asset services unless they are registered as a corporation under Philippine laws. They must also obtain the necessary licenses from the concerned regulatory agencies such as, but not limited to, the SEC and the Bangko Sentral ng Pilipinas. The requirement to register as a corporation does not extend to third-party service providers as described in Section 7.2. Entities engaged in the marketing of crypto assets and crypto asset services may also engage the services of a third-party service provider or TPSP for the marketing or inducement of crypto assets or crypto asset services, provided that the TPSPs may be any person or entity as disclosed to the Commission pursuant to Section 7.6. Marketing activities covered under the CASP rules include social media posts, blogs, comments, non-written communication, banners, billboards, videos, podcasts, recordings, or live streams, among others. Failure to satisfy the requirements that the content be free, made for purely educational purposes, and in good faith shall cause the educator to be considered as an agent or TPSP of the CASP. If the educational content does not make mention of a specific CASP, then the maker shall register as a financial advisor as the case may be. To determine whether a certain instance could be considered a marketing activity of crypto assets or crypto asset services, we are adopting a case-to-case basis approach. We will need to assess and evaluate each situation, taking into account how it was offered and the context of the situation. What happens if entities fail to comply with the CASP rules and CASP guidelines? Section 10.1 of the CASP rules provide that the Commission shall have the authority to impose enforcement actions on CASPs, third-party service providers, or unregistered entities for non-compliance with the CASP rules, the CASP guidelines, and other existing laws pertinent to its jurisdiction and authority. Such enforcement actions include the following: investigatory powers, disqualification and or suspension of directors, officers, or employees of the CASP, imposition of administrative sanctions, fines, suspension, or penalties, issuance of a cease and desist order, issuance of a contempt order, issuance of an order of suspension of operation, and issuance of an order requiring the accounting and disgorgement of profits obtained or losses avoided, among others. Section 12 of the CASP rules further provide that any person or entity who willfully violates the CASP rules and guidelines, the SRC, the FCPA, or any other rule, law, regulation, order, or instruction in relation to these rules may be punished by imprisonment of not less than 1 year, but not more than 5 years, or by a fine of not less than 50,000 pesos, but not more than 2 million pesos, or both, at the discretion of the court. If the violation is committed by a corporation or a juridical entity, the directors, officers, employees, or other officers who are directly responsible for such violation shall be held liable. Meanwhile, there are also prohibited acts under the CASP guidelines. Section 13 provides that no person or entity shall act as a CASP without being duly authorized by the Commission, establish any office or place of business anywhere in the Philippines for the purpose of engaging in crypto asset services unless registered with the Commission, or represent himself falsely to be a subscriber, operator, or provider of a CASP or an affiliate thereof in soliciting or handling any transaction, or to represent falsely in connection with any transaction. Section 14, on the other hand, provides that no person shall engage in the prohibited acts and practices provided in Chapter 7 of the SRC and relevant provisions under its implementing rules and regulations in relation to the trading of crypto assets. This is in reference to the acts of fraud, manipulation, and insider trading in relation to the trading of crypto assets. Alongside the Commission's authority to issue licenses to CASPs is its power to suspend or revoke the same. Under the CASP guidelines, the SEC may refuse, withdraw, terminate, suspend, or revoke the authorization of any crypto asset service provider in the cases described under sections 11.1.1 to 11.1.11. Some of these cases include failure to meet the requirements of the CASP rules and guidelines, or in the exercise of the SEC's sound discretion, is reasonably determined to be unable to meet the requirements of the CASP rules and guidelines in the future, non-use by the CASP of its authorization within 12 months from the date of its grant, the CASP ceases to operate or to provide crypto asset services, breaching of any requirement of the CASP rules or guidelines, or whose certificate of authority granted under the CASP rules has been withdrawn, expired, or revoked, violation of any of the provisions of the CASP rules, CASP guidelines, or any order, relevant law, or regulations issued by the Commission, or any of the other circumstances mentioned in sections 11.1.1 to 11.1.11 of the CASP guidelines. Lastly, I will be discussing the fees and penalties under the CASP guidelines. The CASP guidelines primarily prescribe two fees for CASPs. They are the registration fee and the supervision fee. Section 16.1 provides that for the registration fee, all applications for registration shall be accompanied by an initial filing fee of 50,000 pesos or such amount as the Commission may determine. The supervision fee, on the other hand, is covered under Section 16.2, and it provides that the CASP shall pay to the Commission on a semestral basis on or before the 10th day of the end of every semester of the calendar year a supervision fee based on the gross revenue of such CASP during the preceding year for the privilege of doing business, during the preceding calendar year of or any part thereof. The computation for the supervision fee can also be found under Section 16.2. Similar to the CASP rules, the CASP guidelines also prescribe penalties for certain situations. In the case of late or non-filing of reports, a basic fine of 10,000 pesos is prescribed, including 500 pesos per day of delay. The CASP guidelines further provide that for any violation of the guidelines, certain penalties are imposed based on frequency of violation. For the first instance, a 50,000 peso fine is imposed per violation. For the second violation, a 100,000 peso fine is imposed per violation. And lastly, for a third instance and onwards of any violation of the CASP guidelines, a fine of 200,000 pesos per violation is imposed, including the additional penalty of cancellation of registration. This concludes our discussion on the salient portions of the CASP rules and CASP guidelines. For more information and the full text of the CASP rules and guidelines, we encourage you to visit the SEC website at www.sec.gov.ph. If you have any CASP-related concerns or inquiries, be it about registration as a CASP, or clarification on the CASP rules and or guidelines, you may contact the Philly FinTech Innovation Office by emailing us at casp@sec.gov.ph, that's casp@sec.gov.ph. Thank you for joining today's webinar. We hope that this session has given you a deeper understanding and appreciation of the SEC CASP rules and guidelines. As always, the SEC is here to protect and empower every Filipino investor. Thank you and have a good day, everyone.
All right, that was a very comprehensive video from registration, public offering requirements, to even marketing. Naging mas malinaw na ngayon ang ilan sa mga key provisions ng SEC CASP rules and guidelines. Pero para mas mahimay pa natin ang laman ng mga regulasyong ito, simulan na natin ang question and answer portion kasama ang apat nating panelists. Let's begin with this first question. One of the common sentiments of people about the regulation of crypto assets is in connection with the capability of local exchanges to keep up with their foreign counterparts. What can the government do to ensure that local players do not lag behind in terms of delivering quality service as a crypto asset service provider?
Maybe I'll take this question. Thank you, Angela. Yes, we do get this comment a lot, and it revolves around local players have high fees or they have limited product offering. It's just that this is the nature of being regulated. There would be additional fees, especially with compliance costs and costs related to setting up a business here in the Philippines. But really, based on our study, because we do want to solve this problem, one of the culprits would be lack of local liquidity pertaining to our local crypto market. And because of this, we'd like to encourage the local players to explore offering new products, and we can do this through our regulatory sandbox. So last April, we announced a thematic sandbox for CASPs, so that the local players can explore additional product offerings. And hopefully with this initiative, we can help develop the local market and encourage more liquidity within the jurisdiction.
Thank you. Very interesting po yung nabanggit mo, AD Pao. about the sandbox approach. And totoo rin na importanteng palawakin ang ino-offer na products and services ng local providers or players para mas maraming options ang pwede nilang mabigay sa consumers. It's interesting also to see how the industry is coming or going to evolve in the years to come. For our next question, how does the SEC determine whether a digital token falls under the category of a crypto asset security rather, versus a non-security digital asset?
Well, under our CASP rules, we classify the financial products under two categories. So the first one is a crypto asset. So under this, it is classified as a crypto asset when it takes the form of an investment. Our basis for this is taken from the Financial Products or Services Consumer Protection Act, or the FCPA. Under the FCPA, it empowers the Commission to regulate, among other things, investments. So the second category that we have is crypto asset securities. While this is mentioned under the CASP rules, it is actually governed by the Securities Regulation Code. The Securities Regulation Code has a general definition for what a security is. It provides that securities are shares, participation, or interests in a corporation or in a commercial enterprise or a profit-making venture, as evidenced by a contract, an instrument, or a certificate, whether it is in written or in digital form. So this is very important because regardless of the fact that it is in a written or in an electronic form, for as long as it meets the definition of a security, then it will fall under the SRC. So, but the next question to ask is, what do we use to determine whether or not it is a financial instrument? Here at the SEC, we use the Howey test. So the Howey test actually has 4 elements, and if you meet the 4 elements, then we can classify this. Then we can classify it as a security or an investment contract. So under the Howey test, the first element is that the transaction is an investment of money. So ibig sabihin po nito, may binigay na pera para mag-invest. The second element is that the investment is in a common enterprise. So sa isang company or isang grupo ng tao nangongolekta ng pera para sa investment. And then we have the third element, which is that there must be an expectation of profit. Umaasa yung taong nagbigay ng pera na siya ay kikita. And lastly, that the profits expected are primarily derived from the efforts of others. So meaning that yung kita ay galing sa pagkukusa ng ibang tao at hindi sa sarili nila. So with this, if the crypto asset being offered falls under the definition of a security or meets the elements of the Howey test, then it will fall under the classification of a crypto asset security. However, we should be reminded that the primary determination pa din po ng Commission is in determining whether it is a crypto asset or a crypto asset security is still on a case-to-case basis approach. So ibig sabihin po, what we really look at here is the manner in which it is being offered to the public. Kung papaano po ino-offer ng mga taong ito sa publiko yung product or yung service.
Thank you, Attorney Irish. And from this, we can see na kailangan lang nating balikan yung batas para ma-assess kung securities bang may tuturing ang isang bagay. As society progresses, nakikita natin na nag-evolve talaga yung securities na ino-offer sa publiko, but we just have to go back to what's in the law to really make that distinction.
Sure, Angela, I'll take the chance then, since Attorney Irish discussed about FCPA, mentioned about the FCPA. So under that law, the SEC was given additional powers, especially to prescribe rules and regulations related to financial products, not only in accordance to law, but in accordance also of internationally accepted principles. So, ang implication niya is the SEC will not be limited to be the regulator of securities. So the SEC is also granted the power to regulate financial products, especially investments in general. So that's why we had the mandate now to issue the CASP rules and guidelines. So maybe just to highlight that point, so that everybody will be on the same page.
Thank you for that additional point and clarification, AD Pao. But we have another interesting question that we received from our sign-up sheet. How will the regulations governing crypto asset service providers affect the stock market?
Very good question. Very interesting question. So, as you know, crypto assets is um, so much far from the traditional investment products, especially stocks listed in the stock exchange. And although there are aspects that they are the same, um, but traditional finance or the crypto market is in response to traditional finance, and it's trying to innovate what has been done in traditional finance. But we see the crypto asset market to be one of the ways that we can improve the local economy. So if we have more products in the market, and hopefully Filipinos will be on an investment mindset rather than any other activities, and hopefully that will parang pour into the traditional or the stock exchange, as we all be more knowledgeable of finance, and we experience how to invest in financial products, then hopefully we can steer retail participation into the local stock market.
Thank you for that, AD Pao. Here's another question that was also raised in our sign-up form. Will the commission conduct an ocular inspection and other related tests before approving the application for registration?
I'll take this question. I think this is also related to one of the requirements that we have under the CASP guidelines, which is that we require the applicants for a CASP license to have a physical office here located in the Philippines. We want to assure the public that before any application for registration of a CASP license is granted or approved, the Commission will make sure that the requirements under the CASP guidelines and CASP rules are met. And this would include an exhaustive and comprehensive evaluation and assessment of the applicant and all details related to them. And this would necessarily include if they have a physical office that is located here in the Philippines, which they should indicate in their application.
Okay, thank you. Tama si Attorney Justin. As a regulator, makakaasa po kayo na exhaustive ang proseso ng pag-evaluate sa entities na nais mag-apply for a CASP license. In line with our investor protection mandate, the SEC will go through these applications and make sure na nakakomply ang lahat sa CASP rules and guidelines. Ngayon naman, we also have a query regarding registration. As part of the registration process, the CASP applicant is required to submit the curriculum vitae of all the management and IT personnel in charge of or directly responsible for the system. What prompted the SEC to provide this specific requirement? What issues or concerns are we trying to address by including this particular requirement?
Okay, I'll take this one again since it's related naman to registration. Well, pag nakita po natin yung pag-operate po ng isang crypto asset service provider, necessarily po, very technical in nature po yung binibigay na products or services or mismong pag-operate po nito. And in furtherance naman po of the SEC's mandate of investor protection, necessarily naman po, we need to validate yung expertise po nung IT staff or management or kung sino naman po yun yung nag-ooperate yung nung crypto asset service provider na either exchange or trading platform or kung ano man po yung model nila. Parang tinitingnan po natin dito kung fit po ba yung expertise nila or fit po yung knowledge nila for their assigned duty or task in that CASP.
Yes, iba talaga yung technical expertise na kailangan ng mga nais mag-operate bilang crypto service provider. Kaya kagaya ng sinabi ni Attorney Justine, we deemed it necessary to require the curriculum vitae of the management, and IT personnel of the applicant. Now on to our next question. One of the operational requirements of the CASPs is the establishment of a local data center. It's also provided that in relation to the data center, they have the option to outsource critical IT systems to service providers outside the Philippines under certain conditions, of course, among which is the adoption of additional measures to address risks involved in outsourcing the arrangement outsourcing. Assuming also that the applicant has already decided to outsource this particular function at the registration stage, will they be required to submit as part of their requirements these additional risk mitigation measures right away? Or is this requirement only needed once the application has been duly approved? AD Pao?
Oh yes. Yeah, ideally, the applicant would be in the best position to operate before they apply for the license. Just because part of our evaluation is the readiness of the applicant to operate as soon as we give the license. So ideally for us, they should give us all the requirements now before we can start evaluating, so that when we look at their application, we do it holistically.
Thank you for that, AD Pao. Under Section 8 naman po of the CASP rules, all crypto asset service providers shall be considered covered persons under the Anti-Money Laundering Act. Why is this provision crucial, and what obligations do these providers have in relation to AMLA?
So, una po nating tatandaan that upon the effectivity of the CASP rules, CASPs are now considered as covered institutions. So this was included in the CASP rules in line with the FATF recommendation. So just like any other financial institution, kailangan makover din po natin siya with the AMLA provisions. So, ibig sabihin po nito, nagkakaroon na po sila ng obligasyon na mag-report sa AMLC or the Anti-Money Laundering Council for any covered or suspicious transactions. In connection to this, the very nature po kasi ng industry nila and being that blockchain technology is pseudo-anonymous, maaari po itong maging avenue or paraan for these so-called bad actors to circumvent the laws. So this may be used as an avenue for money laundering or terrorist financing or other unlawful activities. As an example po, sometimes it is used as an avenue to try to clean the funds. Ang ginagawa po nila, akala po nila na kapag pinasok natin sa trading platform, mamamask na nito yung illegality of the funds that were brought inside. They think na porket pinasok na nila is nagmumukha ng legitimate yung funds nila just because it's in the trading platform.
Thank you for that, Attorney Irish. That's a really good clarification. Now, the CASP rules also contain a provision on the marketing of crypto assets and crypto asset services. Can we clarify the extent of the limitation imposed on those who want to produce educational content in relation to CASPs? When can educational content fall under the marketing of crypto assets and crypto asset services?
Actually, this is a very popular question we get at the FinTech office, especially when it comes to marketing educational content. So, bago po natin isagot itong tanong na to, kailangan po natin tingnan kung ano ba talaga yung marketing provisions dito sa CASP rules. Unahin po natin kung sino po talaga pwede mag-market ng crypto assets or crypto asset services. Sinasabi po sa Section 7 po ng CASP rules na ang pwede lang po mag-market ng crypto assets or crypto asset services ay dapat po either isang registered corporation under Philippine laws with the SEC or yung mga third-party service providers or TPSPs ng mga corporation na po ito. Aside from that po, the CASP rules also require that they should get any other secondary licenses required from other regulatory agencies such as the BSP. So now that alam na po natin kung sino pwede mag-marketing under the CASP rules, ano po talaga yung marketing? So under the CASP rules, Meron po tayong listahan kung ano yung mga considered as marketing, but marketing itself is any form of inducement, endorsement, or solicitation, and it qualifies as marketing regardless of the media or channel that it is made through. And this includes educational content, and I think this is covered under section 7.3.6. And educational content here would include articles, papers, presentations, discussions, and tutorials, whether made online or offline. And either it is audio or visual in nature. Very important po yung last line po ng 7.3.6 na nagsasabi po na unless the educational content is made in good faith and purely for educational purposes. So, himayin po natin to. Generally po, educational content will be classified as marketing under the CASP rules. Pero po, kapag ginawa po siya in good faith and purely for educational purposes, hindi po siya makaklassify as marketing under the CASP rules. So, what do we mean here po ng good faith? Good faith is a legal term that would take a long time to discuss po. Pero yung tinitingnan po dito sa good faith is yung intent po ng gumawa ng educational content na dapat po ginawa talaga siya to educate the public or yung magko-consume po ng material. Let me give you po an example. Let's say we have this content creator or a creator of educational content that yung content niya po let's say he's trying to educate the public po and he names an unregistered crypto asset service provider. At this point pa lang po, we can see that this may be an indication po of bad faith because he knows for a fact na what he is indicating in his material is not a registered entity with the SEC. So this may be a situation that we might consider as in bad faith, but I'd like to also take this opportunity to clarify that when it comes to marketing, especially for educational content po, yung approach po ni SEC is that case-to-case basis approach po tayo. Kailangan po natin makita yung binigay po na material or kung ano po mang marketing material yung pinakita po sa public. Kailangan po natin makita to sa kabuuan niya or as a whole, and kailangan po natin makita yung context behind the whole material. The provision for educational content also state po that if the educational content is not made in good faith and purely for educational purposes and for free, then the maker or the publisher of the content shall be considered as a TPSP or an agent of the CASP mentioned in the educational content. Or if the educational content does not make any mention of any CASP po, then the maker shall register as a financial advisor as the case may be. To simplify it po, if there is no good faith or it is not made for purely educational purposes and may mention po nung any crypto asset service provider, yung gumawa po ng material po na yon ay mako-consider po as a third-party service provider nung CASP po na na-mention niya doon sa content. And we have other rules regarding that relationship po under the CASP rules. And if po wala pong mention of any CASP, then necessarily po kailangan niya po mag-register with the SEC as a financial advisor. Thank you.
AD Pao?
The point of Attorney Justin. When enforcing the marketing rules of the CASP, of course, we will be reasonable naman. Just we would really investigate into the totality of circumstances involved. Because intent of intent of a person will be established through the acts prior and after the alleged act. So yeah, hopefully we can talk to the enforcement team as we monitor what is going on in the market. Thanks.
Thank you, Attorney Justine and AD Pao. Itong provision yung isa sa mga bagay na dapat i-take note sa CASP rules and guidelines. Gusto ko lang din i-emphasize yung sinabi ni attorney na kung makita ng komisyon that the content is not made in good faith and not for the sole purpose of educating the public, then maaari siyang makonsider as marketing ng crypto assets and crypto asset services. Importante po ito dahil may tendency these days na ma-blur yung line or distinction between what's educational and what's marketing content. However, as mentioned by AD Pau, it's screened properly naman. They're really going to check the context behind your video and things that you've done prior before making any conclusions. Now, for our next question, I think Attorney Justine, you can also answer this. What are the consequences for a CASP that fails to disclose material risks or makes false claims in their disclosures?
Okay, thank you for that question. Generally, under the CASP guidelines, the main penalty that we have is either the suspension or revocation of the CASP license. And actually, specifically, there is a situation wherein a CASP license can be revoked or suspended if the CASP licensee holder actually makes any false or misleading representation of material facts in any disclosure document or any document that has to be disclosed to the public or submitted to the commission. Aside from that, the CASP guidelines also has its own fines and penalties. So I think you can find this in the latter portion of the CASP guidelines. But for the first instance where there is a violation of the CASP guidelines, there is a fine of 50,000 pesos per violation. If it's on the second instance, it's 100,000 pesos per violation. And for the third instance and onwards, I think it's about 200,000 pesos per violation. We also have under the CASP rules, for any violation of the CASP rules or guidelines, any person or entity that committed this infraction may be punished by not less than 1 year of imprisonment or not more than 5 years, and by a fine of not less than 50,000 or not more than 2 million pesos, or both, at the discretion of the court.
Thank you. But please take note of the punishable acts under the CASP rules and guidelines. Dapat alam natin ang mga bagay na to dahil as shared by Attorney Justine, may kaakibat na mabigat na penalties ang paglabag sa regulasyon. Now, what penalties or legal remedies naman po are available to investors who fall victim to fraudulent ICOs or unauthorized crypto offerings under the new regulations? Perhaps from EIPD, AD Pat?
Hello, good afternoon. So siguro this question meant na what are the legal remedies available, and at the same time what are the penalties imposable to those who violate the CASP rules. Pero I think Attorney Justin already elaborated further on the penalties imposable to those who violate the rules. So siguro we'll start with it mentioned an ICO. So what is an ICO? So for the benefit of everyone, siguro, it's just like an IPO. So it's called an initial coin offering. And syempre, with anything naman, maraming enterprising bad actors dyan, pati yung mga coin offerings na to, pwede nilang gawa ng scam, no? It could constitute misrepresentation or fraud, or an offering na knowing naman nila na hindi totoo yung mga disclosures nila. So, under the CASP rules kasi, Section 6, crypto asset securities shall not be sold or offered for sale or distribution within the Philippines without a registration statement duly filed, pero ito yung importante, with and approved by the Commission. So, mere filing with the Commission does not authorize, no? So, dito yung coin offering is also covered at 6.1. So initial coin offering shall be covered by this same section. On the enforcement power naman ng commission, section 10. It's really all in the CASP rules naman. Pero we have the power to investigate whether any person has violated the CASP guidelines, or the SRC or the FCPA or any other laws for that matter na implemented by the commission. So for investors, let's say kunwari nag-ICO, and then you feel na medyo hindi yun um, yung considerations nyo dun sa disclosures nila, you found out na hindi naman pala totoo. So for investors, ang legal remedies dyan is, well, it could include filing complaints, syempre, with us, the SEC through the EIPD, which we can initiate criminal and administrative actions against the violators. So, pero victims can also pursue other legal remedies with which are within the jurisdiction of the court. Siyempre, kung panloloko yan, you could file estafa cases which is not within the jurisdiction of the SEC. So, sa Section 12, the penalties na diniscuss ni Attorney Justin, just to reiterate, the penalties include fines, imprisonment, and pwede ring ma-cease and desist order against those responsible entities. For investors, again, ulitin ko, you can file complaints with the SEC EIPD, and you can go to courts and file estafa cases if that should be the case po.
Thank you, AD Pat. Now we have another question. I think this was also mentioned in our previous webinar, but of course we must address it again. What are the red flags that investors should look out for when evaluating an ICO or crypto project?
Yeah. So, ano naman to? Valid question naman to. It's similar to part 1, yung question about red flags. No? Pero may bago kasi dito. It says look out for when evaluating an ICO or crypto project. So, siguro I'll answer this question pero with a kulatilla that this is still best left to the individual planning to invest in an ICO. So, the SEC kasi only makes sure that the entities have submitted the necessary undertakings, declarations, disclosures, and statements that are required by law. So, again, di naman ako financial expert, but I will inform you of red flags as a part of the enforcement department. No? So, going back, initial coin offering is a method usually used by companies to raise funds for new blockchain projects. Our crypto audience siguro are very familiar with this already. Ginagamit nila yung offering niyan of their own cryptocurrency as a type of investment similar to a stock offering in a IPO. Okay? So ICOs can be especially vulnerable to fraud yan, as seen in several high-profile scams, which I will discuss later. So vital siya. It's vital to check registrations and validate project teams with credible histories in the blockchain space. So just like IPOs, hindi naman siguro tayo mag-invest or may mga declarations na. You already know who are the people behind the project. Nung nag-background check kayo, may mga hits sila or may mga bad publicity sila na meron silang history ng mga scam. So, I guess it is within the purview na nung diligence ng investor. Kung itutuloy ba nila, do they trust these entities who are backed by these people who have sort of, not to judge naman, pero medyo shady yung or dubious yung past nila. So that's when your own judgment should come in. No? So in contrast to IPOs, ICOs face less regulatory scrutiny kasi, particularly sa US. Pero again, with the fintech team with us, we know naman na they are going to put in more regulatory controls in launching these ICOs. If and when magkakaroon ng ICOs now. Yeah. So we're so again, particularly in the US, medyo faceless yung regulatory scrutiny dito. And they also apply the Howey test as discussed by Attorney Ish to determine if they are subject to securities regulation. So, sige, let's discuss siguro major past ICOs like Ethereum. Ito yung sikat naman to na crypto project before. And it has successfully raised millions, though potential investors should remain aware of both the lucrative potential and the high risks involved. So, one One of the ICOs na medyo malaki yung nakuha, which turned out to be a fraud. So this is in relation to the original question. No? Kaya dapat aware kayo, is this coin called Plexcoin. I think 15 million yung na-raise niya. It was halted by the US SEC in December of 2017. In response to an official complaint that yung founder daw, si Dominic, was defrauding American and Canadian investors. So, ito yung red flag. No? The complaint alleged that si Dominic was advertising an very high return of 1,354%. So, that the SEC determined na syempre, medyo impossible to. You wouldn't be able to deliver on this. So, pushing forward, a group of fake experts, so just like how scammers work, hype nila yung hindi naman talaga yun yung credentials ng mga tao, fake experts, to bring legitimacy to this certain project and trying to obscure his financial crimes, which included defrauding investors in I think may microloan venture din siya. So, to summarize, no, some common red flags that the public might want to take note of, pag sinabi nila na guaranteed or unrealistic yung returns, red flag yan. Any promise of a fixed or extremely high profits is a major warning sign. Syempre, pag unlicensed yung platform, if the project is not registered with the SEC, first of all, it's operating illegally. Second, wala kayong protection or recourse or immediate recourse with the governing body nung entity na yun. So, kunwari, meron, just yesterday, may complaint kaming nakuha. Unfortunately, the complaint or the entity being complained of was offshore and not registered here. So, medyo mahirap na makuha yung pera niyan. It's a substantial amount. So, this just proves the need talaga nung application ng CASP rules, although a lot of other paano ko ba i-explain to? Other fans of offshore accounts which are not registered here would beg to disagree. No? Pero I would invite them otherwise to look into these complaints and face these complainants and say na hindi dapat i-register tong mga offshore na to. So again, another red flag is a lack of transparency. Kunwari, anonymous yung founders, vague yung white paper nila, wala naman talagang clear business model. You should be more suspicious in this one. And lastly, kapag aggressive masyado yung marketing and recruitment nila, schemes that pressure you to recruit others, we've heard this before, di ba? Or to invest quickly kasi limited time offer daw. So this often resembles scam. Okay? So, yun siguro.
Siguro, Angelo, just to add on what AD Pat said, red flags. Siguro, we can take a step back and understand or parang inquire into why the government is regulating securities offerings. So, kasi, syempre, if a person would give out this money to somebody na hindi niya kilala, kailangan meron nag-check kung legitimate ba yung person na yun at legitimate ba yung purpose ng pagkuha niya ng investment. So, just like in any other securities offering, the regulator would inquire into saan gagamitin yung pera pagka kumuha siya ng investment. So, for example, sa traditional finance, pag kumuha siya yung corporation ng pera through a security, sabi niya, kukuha kami pera para gawa kami ng planta or mag-expand kami ng stores namin or gagawa kami ng more branches. So, siguro for the investing public, if they could inquire into saan gagamitin yung pera when the proponents of the ICO gets the money, yun siguro one information that is key for everybody to know.
Thank you, AD Pao and AD Pat. Now, how should consumers prepare if they want to try venturing into crypto trading for the first time? Attorney Irish?
When we're asked this question, usually po tatlo yung main na sinasabi namin. So first and foremost, they should adequately prepare and educate themselves. Libre lang naman po yung internet. And aside from this, they should enter the market cautiously. So personally po, I think that they should develop an understanding at least of the basics of the blockchain technology, of how cryptocurrency actually works, and the risks that are involved in investing in such. Kasi po yung market po ng crypto, it's highly volatile, and marami po talagang mga scam, and there's always a promise of quote-unquote high and guaranteed returns. So second po, we always say na you should invest only money that you can afford to lose. There is no such thing as a sure investment. Lahat naman po ng investment, there's always risk. So again po, promises of sure investments are actually a red flag in the crypto industry. And lastly po, we always suggest to invest only in registered exchanges. Those under the jurisdiction of the SEC are subject to regulation and oversight, as stated a while ago, and they can be held accountable for their actions when necessary.
Thank you, Attorney Irish. Tulad ng mga paalala natin sa nakalipas na webinar, it's important to understand crypto trading before venturing into it for the first time. And katulad lang din po ng iba pang mga investment, dapat the money that people use for investing is the one they're willing to lose. Meaning, hindi dapat isasakripisyo yung necessities, yung mga pang bills nyo, or even savings. We have to realize na it's our money that we will be using to invest, kaya kailangan nating pag-isipan ng mabuti bago pumasok sa mga bagong investment opportunities. Now, can the SEC motu proprio investigate entities who engage in crypto trading without the appropriate registration and licenses from the Commission? ADPAT?
Yes. To answer the question, yes. The SEC, through the EIPD, has the authority to conduct motu proprio investigation. So this means that even without a formal complaint, the SEC can initiate inquiries into the entities suspected of offering or facilitating crypto trading without the necessary registration. So kami naman at the EIPD, we actively monitor online platforms, especially the advertisements. Even on social media, the algorithm naman would feed you these advertisements kapag nag-search ka ng crypto platforms, no? Without the necessary, so facilitating crypto trading without the necessary registration. So we actively monitor online platforms, advertisements, and social media posts, especially to detect violations, and we coordinate with other regulators and agencies, syempre, to take down the unauthorized platforms. Just recently, I think a month ago, we actively coordinated with our partners naman to try to enforce the rules when the CAS rules came into nung nagka-regime na, no? So this proactive stance is meant to safeguard naman yung investors and maintain yung integrity ng markets natin.
Thank you, ADPAT. It's all done to protect, of course, those who may enter into crypto. Now, what information would you need to assess whether an investment is risky or not? ADPAO? Maybe you have some tips.
Yeah. So, siguro, this was parang part of the discussion na earlier. But just to highlight parang what can be parang basic information that you would need in assessing whether a crypto asset is worth investing or not. So, under the rules, we require the service providers to provide a disclosure document, and that document will serve as basis for the investors to assess whether this is worth their money or not. So, with that prescription, the following information would be needed. So first is sino ba yung issuer ng crypto asset. So information about the offerer of the crypto asset as well as the issuer, and then key features of the coin or the crypto asset, as well as the risks involved in those models, the rights and obligations attached to what you're buying, and some other information like underlying technology that is being used by the coin or the project, and other relevant information. So please look into these documents if when you are dealing with crypto asset service providers.
Thank you, AD Pao. And here's one question from Facebook user Maeve. Can an entity apply to register a CASP in the SEC despite the moratorium on VASP licensing from the BSP? And if yes, does this mean that a CASP is not allowed to conduct VASP-specific activities such as flat currency to cryptocurrency exchange and vice versa, and unless partnered with a licensed VASP or license itself as a VASP?
Yes, siguro just a brief background on the question. So in the Philippines, there are two main regulators concerning crypto assets. First is the BSP as the regulator of payment services and money service businesses, and the SEC as the regulator of investment platforms and offer of investment products. So she mentioned the VASP license. So the VASP license is the license being issued by the BSP for money service businesses related to crypto. So meaning yung nagko-convert ng crypto to peso to crypto and vice versa. It includes yung safekeeping nung cryptos. Well, the SEC is the focus of the regulations of the SEC is on the trading activities. So for example, bibili ka na, gusto mo mag-trade ng crypto, or there are other products that are related to crypto trading. So as to the question, we beg the indulgence of the public that given that recently the BSP just issued their announcement that they will not be lifting the moratorium, meaning hindi sila mag-give out ng new VASP license. We are coordinating with them to find a model for the Philippines that can work for everybody. So we beg the indulgence of the public that in the next few weeks we'll announce what would be the requirements for a VASP and a CASP, and hopefully we can find a beneficial model for everybody.
Thank you, AD Pao. There's also another question on Facebook from Jeronimo Aumentado. He asked rather, with the recent rules for CASPs, what are the SEC's top 3 priorities in its regulatory oversight? Is it the prevention of scams, financial stability, or something else entirely? And lastly, as a consumer, how can I verify if a CASP is officially licensed by the SEC? What are also the red flags I should look out for that indicate an unlicensed or fraudulent platform?
So top 3, no, parang Miss Universe yung question. But yeah, siguro the top priority for the SEC is for the service providers to be responsible in informing their customers what are the risks involved in the particular financial product. Given that, to enforce that objective, they have to be registered in the Philippines, so that we can check into their competence to give out that information and to provide the crypto asset services to Filipinos. So yeah, so we just want the service providers to give the necessary information for the Filipino investors to make a smart investment decision.
You have anything to add,
Yeah,
AD
siguro,
Pat?
could we run the question again? So the question was, with the recent rules for CASPs, what are the SEC's or the SEC's top three priorities? No? Is it the prevention of scams, financial stability, or something else? So, syempre siguro, as much as possible, balancing of all of these interests ang goal ng SEC. So, may enforcement side, pero may investor protection side, pero we also want to, make the space proliferate, di ba? Gusto natin na at least makahabol din tayo, but not without the proper regulation in place. Pero ito, interesting to, what are the red flags I should look out for that indicate an unlicensed or fraudulent platform? Buti na tanong to because I wasn't able to touch on this on the previous question. Kasi interesting to because there are a lot of complaints, no? Madali lang naman, hindi naman sa madali, pero due diligence, I'll give you a background. There are a lot of complaints na nawawalan sila ng pera because they fell for what we call a spoofed website or a spoofed cryptocurrency platform. Pag sinabi spoofed, ginaya lang. Sobrang dali na lang kasi gumawa ng website ngayon. You just download pictures, parang plug and play na lang gumawa ng website ngayon. And then, isang pinaka-red flag dyan is meron magko-contact sa'yo through a messaging platform and gives you instruction on what website to go to. Itong mga website na to, usually very tacky yung itsura nila. Tacky in a sense na hindi professional yung paggawa ng website. That is one obvious red flag. You could also do your own due diligence. Just Google the website. Usually, people would spot it for you. Nasa comments yan. Or say ba na nasa Reddit minsan. Yan. Am I allowed to say that? Pero, yeah. Makikita nyo naman. Pero syempre, 2020 ang vision natin. After the fact, usually, wala pera. So, I'm reminding you guys, or the public siguro, or the for this particular question, meron at meron talagang fake na platforms. If i-feed nila yung actual crypto market na nagfa-fluctuate, kunwari legitimate sila, pag nag-deposit ka, fa-flash nila yung amount dun sa account mo. Pero hindi mo na ma-withdraw yan. Hindi mo na ma-withdraw yan because they're always going to have this excuse na you have to pay a 23% withdrawal fee, etc., etc. So, yung pag sinabi kong tacky yung itsura nila, you would normally see na pare-pareho yung pattern nila. May rectangle dito, may rectangle dito. Limited yung buttons. Hindi masyado mabilis yung website. And it's unlike yung iba naman, hindi ko sinasabi na scam websites eh. Yung ibang platforms. We're not saying that it's a scam website. We're just saying na other offshore entities are not registered in the Philippines, therefore lacking the required, kumbaga, KYCs na should be available to the regulator in the Philippines. So I would like to make a sort of delineation with an entirely scam na website versus those unregistered. Baka sabihin nila, scam yung ano.
ED?
So you have to add on to the answer, he's asking for top 3 priorities, but siguro one up ko siya and I'll just give one, and that's investor protection. Investor protection is the objective. That's why we used the Financial Consumer Product Protection Act in enforcing the rules over crypto asset service providers. And if you would see that law, it gives out the rights of a financial consumer, and we adopted that in the CASP rules. So we invite everybody to look into that provision of the CASP rules, so that they are informed of their rights, and the regulator, the SEC, is here to make sure that the rights of a financial consumer are protected.
But I'd also like to thank ABP for that really good example. It's good that you raised. My microphone was off, but I hope you guys can hear me clearly now. I was just thanking our two panelists here, AD Pat and AD Pao, for sharing insights. But overall, the Commission's goal is really just to protect the public. Now, we also have another question from Sir Tim, also from Facebook, I believe. Perhaps we should also touch, he said, on the high fees and lack of liquidity in local exchanges, as these are key reasons users turn to offshore alternatives.
Yes, we agree, and we really want to solve this or help solve this liquidity problem, because we see, of course, liquidity is not just a regulator problem but also an investor problem. Like, for example, hindi naman kami yung magbibigay ng liquidity sa market, but it's really the investors that would bring the money in sa local exchanges. And one strategy that we are taking, as mentioned earlier, is that we want the local players to have more products, so that the Filipino investing public would be more interested in engaging with local exchanges, and because of that, they can minimize the fees, and so we are trying to lessen the reason for Filipino investors to go offshore.
Well, do you guys have any final tips or things to share to our viewers? Yes. Yes. So we're doing our best to accommodate as much questions as possible, because this is already the second part and the final part of our webinar series in relation to CASPs. So ask away. We're going to do our best to answer them as clearly as possible. There's also another question from Tim. He said that phishing remains the leading cause of scams. Kahit sa mga regulated apps rather, nangyayari po ito. Wouldn't it be better to work with offshore exchanges and strengthen user education rather than imposing immediate bans? What happens to investors who suddenly lose access to their funds as a result of these bans?
Okay, sige. So, we'll try to structure the question as we go along. No? So, phishing remains the leading cause of scams. I'm not sure kung saang data niya nakuha to, no? Pero we don't doubt naman na malala rin ang phishing scams sa Pilipinas. Phishing kasi is sort of how would you say this? It's tricking you to give out or click on something for your device to be able to give out other information which you did not intend to give out naman. And this information would be used to access siguro certain apps in your phone or whatnot. No? Sabi niya dito, kahit sa mga regulated apps gaya ng GCash, nangyayari ito. I don't know how true that is, so I can't comment on that one. And paano naging phishing, or how did it affect his, or baka siya yung na ganon, GCash account. So let's go to the other question na lang. Wouldn't it be better to work with offshore exchanges and strengthen user education? Sige. No one said that we're not working with offshore exchanges naman ata. Because as we've said before, everyone, offshore man o nandito, pwede naman mag-register. They just have to follow the guidelines on registering. Strengthen user education. I think this is part of what we're doing now. This is to strengthen user education. So rather than imposing immediate bans, yung pag-impose ng ban, again, just from the part 1 ito dati, no? Immediate kasi is a little, pwede natin siyang, I don't know, pagdebatehan kung ano, what is immediate ba? Because last year pa, alam ng public na lalabas ang CASP rules. And these bans or these entities which are banned, I would think that they would also, could only guess that they know na maglalabas ang Pilipinas ng ganito. Given siguro, hindi ko naman lahat, given siguro na meron naman silang market researchers and also policy or compliance team which monitor the rules or kung ano man yung mga rino-roll out ng mga bansa where they operate. So, yun, medyo contentious yung word na immediate bans. Siyempre, on the enforcement side, they might think na medyo bias yung answer ko doon. Pero that's my take on it. So, what happens to investors who suddenly lose access to their funds as a result of these bans? Siguro I'll answer this with another question. No? What happens to investors who suddenly lose access to their funds? Pero yung question ko dyan, if we don't ban it, what happens to future investors pa who keep putting money in unregulated spaces? Tapos, ano ba, hihintayin lang ba natin na may masamang mangyari and then people will call out that the SEC did not do anything to protect these future investors. So, yun siguro pagbabanggain ko na lang yung dalawang questions na yun. And it's very hard, admittedly, to balance those two interests.
Thank you for that, AD Pao, AD Pat rather, for providing a parallel that we can all probably think about as the webinar is about to conclude. However, I would like to ask if anyone has a final message or piece of advice that you'd like to share to our viewers today.
So siguro, final message from particularly from the fintech office is that we're open to feedback. So if you have any feedback with the current rules or you have suggestions on how we can make the crypto market in the Philippines more flourishing, then we're all ears. And we invite you to send your questions or your suggestions to casp@sec.gov.ph. Yeah.
Yeah. So on the enforcement side naman, ang siguro favor ko na lang sa public is shared responsibility po ang diligence in terms of investing. So again, remember the red flags. Cliche kung sa cliche, walang magsascam kung walang magpapascam. That's true naman eh. Kung hindi laganap and kung hindi ko first hand or hindi namin first hand naririnig yung mga kwento ng mga nasascam, then we wouldn't be here talking to you right now and trying to defend the enforcement actions that we have been taking. It is more of a necessity than hindi man siya out of just we want to have a regulation for the heck of it. We want to regulate it kasi meron talagang masamang nangyayari. And we can't leave it up to the regulators lang. Dapat individually, kung may mga pamilya kayo, I'm sure meron kayong naririnig siguro over lunch, over dinner. Sabi niya meron siyang magandang investment na nakita, nilapitan siya ng kapitbahay na ganyan-ganyan. Then maybe it is within your responsibility to inquire kung mas nakakaalam kayo in that aspect and help us protect the Philippines from bad actors within and without the Philippines in terms of these scams proliferating right now.
So thank you to you both. And all right, that ends the question and answer portion of our webinar. Maraming salamat po sa aming speakers from the PhiliFintech Innovation Office, AD Pao, Attorney Irish, and Attorney Justine, and from EIPD, AD Pat. Our two-part webinar surely gave us a lot of insights about the regulations governing crypto asset service providers, from the registration process to the penalties for non-compliance. We hope na naging mas malinaw ang mga regulasyon ng komisyon hinggil sa CASP. To formally close our webinar, let us all welcome Commissioner McGill Brian T. Fernandez.
Magandang araw po sa ating lahat. Sa ngalan ng Securities and Exchange Commission, maraming salamat po sa inyong pagdalo sa two-part webinar na ito sa ilalim ng SecCan Initiative. Ito ay bahagi ng aming patuloy na pagsisikap na mailapit ang edukasyong pampinansyal sa publiko at magabayan ang mga Pilipino sa paggawa ng tamang desisyon ukol sa pananalapi. Over the past sessions, we heard from our colleagues in the PhiliFintech Innovation Office and the Enforcement and Investor Protection Department of the SEC on a very timely subject, crypto assets, which present both opportunities and risks. For investors, prudence is essential. Hindi po lingid sa ating kaalaman na ang mga scammers ay patuloy na sinasamantala ang complexity ng crypto assets at ang appeal ng mabilisang kita o gains sa crypto na nag-uudyok sa publiko na pumasok sa mga too good to be true schemes. Ipinapakita ng mga panganib na ito na higit kailanman kailangan natin hindi lamang ng epektibong regulasyon, kundi pati ng maalam na pakikilahok ng bawat isa. At the same time, the SEC takes a developmental approach to regulating crypto assets. Our goal is not to stifle innovation, but to foster a safe and dynamic environment where our markets can grow with integrity. In the process, we recognize that frustrations may arise along the way, but we believe that this can and should be transformed into constructive action. That is why we urge you to collaborate with the Commission. Magtulungan po tayo. Share your ideas, your concerns, and your innovations. You can count on the SEC to listen, to act, and to always protect the investing public. And we hope for the same commitment from you, because only through our collective effort can we ensure that our crypto market grows on a strong foundation of trust. Maraming salamat po at muli, magandang araw sa ating lahat.
Thank you very much, Combray. Kung meron pa po kayong katanungan hinggil sa CASPs, maaari kayong mag-email sa casp@sec.gov.ph. Para sa iba pang fintech-related concerns, mag-email lamang sa fintech@sec.gov.ph, and to reach the Cyber and Forensics Division, kindly email epd-cybercrime@sec.gov.ph. You can also reach out to the Enforcement and Investor Protection Department at epd@sec.gov.ph. Para sa iba pang katanungan, feel free to reach out sa official channels ng Securities and Exchange Commission. Bisitahin lamang ang SEC website at www.sec.gov.ph at ang iba pang social media pages ng Komisyon para sa mga karagdagang kaalaman. Maaari rin kayong tumawag sa aming hotline 8250-4521. Fully operational na po ang ating bagong hotline simula pa noong September 1. For more services, you can also download the SecCheck app. Available po ito sa Google Play Store at Apple App Store. Through this app, you may verify if an entity is authorized to solicit investment or engage in lending and financing activities. Maging mapanuri po tayo at manatiling ligtas. I-download ang SecCheck app. Paalala lang din po sa ating partners, huwag kakalimutang sagutan ang online evaluation form by September 18 para makatanggap ng e-certificates for this webinar. Just visit the link flashed on your screens or scan the QR code para ma-access ninyo ang evaluation form. Ipopost din naman po namin ito sa aming Facebook page and sa caption ng live video na to. Muli, participants have only until September 18 para sagutan ang evaluation form upang makatanggap ng e-certificates. Kung meron kayong na-miss sa webinar na ito, huwag po kayong mag-alala. Maaari ninyong itong balikan at panoorin ang replay sa aming Facebook at YouTube. Para sa karagdagang impormasyon at iba pang learning sessions, i-check nyo rin po ang website ng SEC. May kita roon ang buong SEC Campaign Network webinar series. Muli, ako po si Angela Ocol. Maraming salamat at see you again sa susunod na webinar. Magandang araw po sa inyong lahat.